A wonderful evening, everyone. Thank you for joining us today, where we're going to be discussing inheritance laws here in the UAE. My name is Ayman Gebre, Head of Wealth Advisory here at Sarwa, and I'm joined by a special guest by the name of Tasleem Sayani, who we've had the pleasure of actually having this call 2 years ago, Tasleem, when we were talking about inheritance laws, unpacking the mysteries. It's typically a very difficult conversation for many households to have. So I'm glad that we're having this discussion today. I think it's an imperative one, especially that we're working with so many different individuals from different backgrounds, different faiths, and, operating out of the UAE and beyond the UAE borders. I think it's important to have these discussions at some point, during your investment journey. What are we going to be talking about today? We're going to be talking about UAE laws, wills, wealth beneficiaries, and more. And as I said, I'm joined by a wonderful guest, Tasleem Sayani, who's going to be taking some questions as soon as we start the presentation. And maybe what we can do is maybe we can do a brief introduction about yourself, Tasleem. And I might start by just letting everybody know a bit about yourself. Tasleem is an English qualified solicitor and a DLAD licensed legal consultant. Been operating well over 15 years here in the UAE. Tasleem typically works with private clients in relation to a range of items, including both Sharia compliant and conventional inheritance and succession matters. Furthermore, she supports clients from diverse backgrounds that encompasses various nationalities and religions in relation to wills, guardianship, cross-border estate administration, and foundation structures. She has significant experience in this field, and I just wanted to say thank you for joining us today, Tasleem. And maybe we can start it off, what are we going to be covering today?
Thank you. Thank you so much for having me again, Ayman. It's a pleasure to be here. Thank you to you and your team. So a really important topic. We're going to be talking about a lot of different aspects of wills and inheritance laws, and particularly UAE inheritance laws. So we'll start off with a will and what happens if you don't have one, what you can include in one. We can then briefly talk about Sharia law, because it's quite important to have a bit of an awareness, because we do live in the UAE. And Sharia law in the context of inheritance, and we'll go through an example to show how it works and how it applies to a family. We'll then briefly talk about assets, what do they include, and guardians for minor children, which is another really important part of this subject. And then I'll go through a brief summary of the UAE inheritance laws, because one of the major changes to today's session from when I spoke to you 2 years ago is the recent developments in legislation. We'll then talk about the formalities for UAE wills and the types of UAE wills, and then we'll end on those life events that everyone would typically go through, which should trigger a review of any existing wills that you already have in place.
Very important one. I do have a number of conversations with individuals, Tasleem. I think I shared this with you earlier this week, where individuals have had wills in place many, many years ago, but they've never gone back to revise to see if there's any changes that are required, if there's any adjustments that need to be made, or even validate those wills themselves. So I'm glad that that's going to be one of the topics that we're going to be talking about today. And speaking of changes, key one, and there was a significant change that you and I discussed earlier this week, where and this kind of comes back to the disclaimers that we normally have, that look, we can't predict the future. And whether it comes to investment discussions or whether it comes to laws that may be updated or that may change. So we don't have a crystal ball. So it's important to take that into consideration and, of course, ask the relevant experts at any point in time, just to ensure that, the laws still apply, or that what the provisions that you have in place are still valid. And of course, we are not solicitors here at Sarwa. I am not a solicitor. I am a financial advisor. And I would not ask anyone to ask me for any advice when it comes to inheritance laws. This is why we have experts like Tasleem, who's a solicitor who practices this day in, day out. So in the cases like this, especially in unique events or, unique circumstances to yourself, I want you to, be able to understand that our conversations today should not be interpreted as one-on-one financial advice. I will be providing Tasleem's contact details towards the end of the presentation. So if you are interested in having a conversation further about your family's estate planning, I do welcome you to reach out to her directly. So without further ado, what are we here to do? Look, very simply, our mission is to help you become financially empowered. And whether it be helping you grow your wealth or help you become much more knowledgeable throughout that process, knowledge is power. And the more informed you are, the more empowered you will be. And to kind of just walk you through the journey of Sarwa over the years. For those who are in the audience today who've been with us since the very beginning, you know that our flagship product, what we were more famously known for back in 2017, is our Sarwa Invest proposition, which is essentially the proposition in which we will provide you with a recommendation of the appropriate risk, the appropriate portfolio, and we will manage that entire portfolio for you. There was a significant change. And basically we were, heeding the call of our clients who were really incurring a lot of expenses, transferring money to their offshore account, where we upgraded our license in 2020 to become asset managers. And that is a very important point that actually relates to a later point that I'm going to bring up in a bit, but which enabled you to be able to fund locally. In this case, you're able to fund locally at our Emirates BD account, and we're able to transfer the funds on your behalf directly to your account overseas. And that's actually one of the benefits to becoming an asset manager. Another benefit, which actually, indirectly allowed for the creation of wealth beneficiaries at Sarwa, is that you are now able to nominate a beneficiary on your Sarwa Invest and Sarwa Save accounts. And the reason being for that is just due to the legal structure of Sarwa Invest, where we essentially nominate you as the beneficiary owners of these assets. We purchase these securities and nominate you as a beneficiary, which gives you the ability to enter into a legal agreement to nominate a beneficiary. But not only that, it also allows you to basically be protected from estate tax, which is a very topical concern for a number of individuals here at Sarwa. That was back in 2020. 2021, again, more in developments and improvements. We launched the Sarwa app itself in 2021. Later in the year, we launched crypto portfolios. We launched Sarwa Trade in November 2021, followed by Sarwa Crypto in May 2022. The ability to nominate multiple accounts or create multiple accounts. And this is, I would say, very applicable in our conversation today, because we have a number of users who will set up a joint account for maybe the husband and wife for their long-term retirement needs. And they'll have separate accounts for their kids and may have a separate account for maybe a house purchasing goal that they may have in mind. And all of this essentially culminated in 2022 when we launched the service of being able to nominate a beneficiary. A lot of work went into it, a lot of discussions, whether it be from a legal perspective, regulatory perspective, even courts perspective as well, too, that allowed this facility to be created. And more recent development would be Sarwa Save. For those who are not aware that you can nominate a beneficiary, just want to let you know you can. You need to proceed through your app. If you go to the menu section, you'll see a long list of items in the menu, and there is a line item, I think it's about 3 rows down, that says nominate a beneficiary. You are able to nominate a beneficiary for your Sarwa Invest, Sarwa Save accounts. If you want to know how to do it, if you want some guidance, scan the QR code. There's a really easy to follow step-by-step FAQ. If you follow the QR code here, worst comes to worst, just go to our homepage and go to our FAQ section, type in wealth beneficiary, and it'll give you a step-by-step guide on how to do it. You can nominate single accounts. You can also nominate joint accounts if you want the added protection or added layer of protection there as well too. So that is a possibility. At this point in time, for Sarwa Trade / crypto users, you are not able to essentially nominate a beneficiary. Unfortunately, the legal structure does not permit us to help you nominate a beneficiary for Sarwa Trade and Sarwa Crypto. Essentially, those are individualized accounts domiciled in the US, and that does not permit you as a result. But it is something that we are exploring. We are trying to find a solution, especially as Sarwa Trade has become quite popular over the last few years. And definitely there's a number of users using it. So it is definitely on the roadmap to try to find a legal solution to allow you to nominate a beneficiary for Sarwa Trade. What does it provide you to nominate a beneficiary? Well, again, assigning a beneficiary, allows you to have peace of mind, really, at the end of the day. You can nominate a legal spouse, a child, parents, siblings, whether it be natural step or adopted children for that matter, or siblings. Beneficiaries can also be unrelated to you, but I would advise that they are appropriately identified. If you identify a random person, it'll be very difficult for that person to, first of all, be aware if they have no connection to you, because it does require that individual to inform us of your passing. That's unfortunately one of those loopholes in this whole process where it's like, you know, you hear about these accounts in the US where the person's passed away 20 years ago and that account continues to flourish and grow and have ridiculous double-digit returns because nobody's informed the bank that the person's passed away. So I would recommend that if you are going to nominate a beneficiary, be someone who's close, somebody who is familiar to you, who's able to inform your financial institutions that something has happened to you. And again, I'm being very direct. I know it's an uncomfortable conversation, but I think we're all adults, and I think it's important to be able to have an open discussion about this. If the assigned beneficiaries are below the age of majority in the UAE, which is 21 years old here, then in the event that something should happen to you, we can only release the funds to their legal guardian. For those who have children and probably, you know, have asked, you know, your bank or maybe have asked Sarwa if you can open a bank account or investment account for their child, you would likely have been told, no, you're not. It's because they have not reached the age of majority. And that's the same situation here. So the only person who could be the benefactor or the beneficiary in this case would be their legal guardian. And that would be somebody who's appointed as such by a valid court order. And we'll talk a little bit more about that, the steps as to how you can do that. You can assign multiple beneficiaries, by the way, so you're not mandated to just pick one person, you know, for the entirety of your portfolio. I've seen some situations where one account is nominated, you know, nominates another individual, and then another account has another individual. You can split beneficiaries as well. You can do 50-50, 33-33, you know, and 33.9999, essentially to equal to 100%. You can change your beneficiary at any point in time through your Sarwa mobile app. So if you've updated your beneficiary as of today and you'd like to change it maybe 6 months from now, a year from now, due to circumstance changes, you can, right? And this, I think, is a really important tidbit. And this is something I know you and I were going to talk about now, Tasleem, about informing, you know, those who are close to you, you know, of financial, I would say, relationships that you may have. More often than not, a lot of individuals will take all the necessary steps to ensure that their family is able to receive their inheritance, but they just don't tell them where they can obtain this information. In the UAE, we have over 50 banks. So imagine your loved ones going door to door, bank to bank to try to find out if you have any relationships there. Well, with Sarwa, you know, what you can do when you nominate a beneficiary, you do receive a certificate that doesn't highlight your assets, what value they have, or anything of that sort. But it's a certificate, which I think is very important to make sure it's available to your, you know, family members or again, next of kin or those who are close to you, so that they know that, hey, you know, this person has something at Sarwa. So you can choose to share that with them if you'd like. On that note, I think I've had my 5 minutes there, Tasleem, or more so. I'm going to start maybe asking you some questions, if that's all right. And for those in the audience, by the way, who are watching right now, this is meant to be an open discussion. And there is a Q&A section. And I welcome you to post your questions there. And you don't need to wait until the end of the presentation. You can post them now, but we will take them up towards the end. First come, first serve. So feel free if you have any burning questions that you've been uncomfortable to ask or you didn't know who to ask, feel free and we'll do our best to address them for you. So on that note, Tasleem, I'm going to catch my breath for a second. When people think about inheritance, the first thing that comes to mind usually is a will, right? Now, you know better than I, but most of us don't have wills here in this region, let alone any other regions, right? Now, why is it important to have a will?
Well, it's important to have a will because, first of all, let's go back a step. What is a will? A will is a legal document in which you set out your wishes as to who should receive your assets, your wealth, your investments, personal possessions, etc., in the event of your death. So it's a simple document, or it can be a very simple document, but it has such significant impact, not only for yourself and your own assets, but for your family as well. So it follows that if you don't actually have a will, there is no legal declaration or legal statement which you have entered into to confirm who should inherit your assets in the event of your death. And if that doesn't exist, then there are, and you do own assets, and assets we'll see in a moment can be anything from a bank account to a property, etc. But if you don't have a will, then those assets have to go somewhere to someone in a particular share. Without you specifying who and how they should go, the law is going to decide. And what that basically means is that there are there are default inheritance laws in every country, and they will determine how an estate is to be divided if there is no will in place. And that can have pretty dire consequences depending on what your family circumstances are. And what I mean by that is if, for example, you're part of a family structure where perhaps you're not married to your partner, or you have children who are not your natural children, so perhaps you have stepchildren or adopted children, or you have a family who you're not necessarily related to by blood, but you are supporting them financially, or you would like them to benefit from your assets. Without a will, the default inheritance laws of most countries will not give them anything. So then what follows is that they would have to go to court and basically forcefully try and claim a share of your estate, which should have actually been their entitlement if you put a will in place. There are lots of other sort of other important issues that you can include in a will, which if you don't have a will, they're again not documented. Examples include executors. So executors are typically those individuals who will administer your assets. So they will, number one, have an awareness of what you own. They will pay off any debts and liabilities, and they will manage the whole process and ensure whatever you have stated in your will takes place, and whoever you have named to benefit actually does benefit. So if you don't have a will and you've not named executors, who's going to take on that incredibly important role? Again, it will be decided by the default inheritance laws in the relevant country. Other important things like funeral wishes, you know, that's really important to some people. They want to be buried in a particular place or a particular location, or they don't want to be buried, they want to be cremated, etc. A will is a document which you would include all those important decisions.
It's essentially a document that speaks on your behalf, really, at the end of the day, right? I mean, you're not here to advocate for yourself, and to also those special arrangements or those complex relationships that we may have in our lives, right? And if you're not there to advocate, then you need some sort of document in place for it. Now, the majority of us are, I would say, I think it's a fair assumption to say, are expats within this region. And, some of us are familiar with the default rules, laws. We hear the word Sharia a lot, but I don't think a lot of us really understand what is Sharia. And maybe you can just walk us through that a little bit.
Sure, yeah. So it's important, I think, if you live in the UAE to have at least an awareness of what Sharia law is, and I suppose in the context of inheritance, how it applies. So to start off with what it is, of course, a religious system of law. The Sharia law is derived from the Islamic holy book, which is the Quran, but it's also derived from other supplementary sources. So because it is not a codified law as such, it requires a Sharia scholar to adequately interpret it and apply it to different situations. So in the UAE, we have the personal status law, which is based on Sharia law. And the personal status law basically covers all those personal status matters, all those sort of relationships which give rise to a legal consequence. So, for example, getting married, getting divorced, dealing with guardianship of children, and of course, inheritance. I often get asked about whether Sharia law applies to everyone here. Does it apply to only Muslims? Does it apply to particular nationalities? And actually, the answer to that has very recently changed. So if you are a UAE national and you're a Muslim, it will always apply to all matters of personal status that relate to you. If you're a Muslim who's not a UAE national, but you're of a different nationality, it will apply to you if you don't take alternative steps to, for example, register a will through another process that has recently been introduced through the Abu Dhabi Civil Family Court. And I'll talk more about that in a moment, but the bottom line is that if you're a UAE national Muslim, Sharia law will always apply. And if you're a Muslim individual of a different nationality who has taken no alternative steps, then Sharia law will apply to your inheritance as well. If you're not a Muslim, then again, there have been some legislative developments. And if you don't have a will, then there is an alternative distribution that would apply to your estate. Okay. And I think it's also important just to briefly talk about a Sharia compliant will as we're talking about Sharia, because over the years and still, I guess to this day, I get asked about a Sharia compliant will. A lot of expats who come to the UAE, they've heard about the inheritance situation, it's various stories, and they sort of hear this term Sharia compliant will, and they think, right, I'm in a country, an Islamic country, and so therefore I need a Sharia compliant will. In most cases, it's not a Sharia compliant will that an individual expat will need to put in place. A Sharia compliant will is quite a specific type of a document. It's typically a will that will be made by a Muslim individual who wants to deal with their inheritance within the Sharia framework. And a Sharia compliant will fits in that framework by allowing a Muslim to give up to 1/3 of their estate to somebody who's not Sharia heir. And I'll show you an example of how Sharia heirs are determined in a moment. But I think it's just important to mention that Sharia compliant will is not necessarily the type of will that's going to be suitable for all expats who live here and work here.
My takeaway from this is, so if you're a UAE national, the assumption is that you're Muslim, then automatically Sharia is applicable in this case, right? If you are an expat Muslim, there are new provisions in place now that, and I don't want to go too far ahead, but there's provisions in place now where Sharia is not necessarily the default. And the same thing as well too with expats, non-Muslims, there are provisions in place now that doesn't necessitate that Sharia is the default. That's my understanding from this conversation.
Yeah, apart from the second point, so if you're a Muslim expat and you don't have a will made in accordance with the Abu Dhabi rules, then Sharia will be the default. But if you don't want Sharia to be the default for your inheritance, then you have the option of registering the will through the Abu Dhabi Civil Family Court.
Okay.
And I'll elaborate on that.
Thank you for that, Tasleem. I think it'd be good. Let's maybe dive into what does it mean from an inheritance perspective, Sharia law.
Sure. So if we have a family, a sort of fairly standard family setup, husband, wife, children, son and daughter, and parents of the husband. If we assume the husband in this case and the whole family are Muslims, and no alternative steps have been put in place for dealing with inheritance, any assets that the husband owns or any half share in any jointly owned assets will pass in accordance with the Sharia inheritance distribution. So you'll see on the slide, all of those individuals will inherit from the husband's estate. And you'll see on the next slide, the shares that they will actually inherit. So the wife, as long as she survives him, will inherit 1/8 of the husband's estate. The mother and father will each inherit 1/6, again, as long as they survive the husband and as long as they are his natural blood parents. And then the remainder of the estate will go to the son and the daughter, with the son inheriting double the share of the daughter. And again, the children will inherit as long as they are the deceased's natural children, so his blood children. Okay, so I usually go through that exercise and that sort of an illustration with clients who want to sort of understand exactly how it applies, because you hear a lot about Sharia law will apply to your assets. What does that actually mean? And there are a lot of misconceptions about maybe only fathers inheriting or sons inheriting and females not being allowed to inherit, or a wife not being allowed to inherit. And so I think this is quite a good illustration to show that actually the whole family will inherit, but the different shares that they will actually inherit. The other misconception is that if it's actually a female that passes away, say it was the wife, then from her estate, everything will go to her husband. So we flip the coin, as it were, and we show an illustration of wife dying, this time leaving the same family, so husband, her mother and father, and a son and daughter. And if you see on the next slide, the distribution, it's very similar. So again, her husband will inherit from her a quarter of her estate. Her own mother and father will inherit a sixth each, and her son and daughter will inherit, with the son inheriting double the share of the daughter. And again, same rules apply. Everybody has to be blood relatives, and natural relatives. And yeah, so the distribution is very similar. So the whole family will benefit. It's just the shares that differ slightly.
So by and large, this is the structure that is followed, I would say, if not all the time, majority of the time, unless there's special circumstances. Is that fair to say?
Yeah, it's fair to say. Now, obviously, each family will differ. Some families may have, for example, the mother of the deceased husband has passed away. So in that case, mother's share, the 1/6, will just fall into the remainder. So the children will actually inherit a bigger share. There are, under Sharia inheritance distribution, there are shares that are fixed, and that there are shares that are variable depending on who else survives. So typically, a wife's share will be fixed at inheriting either 1/8 from her husband if the husband leaves natural children, or 1/4 from her husband if the husband leaves no natural children. So a wife under Sharia will only ever inherit a maximum of 25% from her husband. Similarly, the parents, if there are children, if there are sons, will always inherit a fixed share of a sixth each, as long as they survive. And then children will typically inherit the remainder, so their shares are more flexible depending on who else survives the deceased. But it isn't a general principle under Sharia law that the son will typically inherit double the share of the daughter.
Okay, well, thank you for that, Tasleem. I mean, so then this brings upon other questions now, because some the financial picture of individuals can be quite complex. It's very simple if everything is in one bank account, very easy to kind of split it. But we're talking about, it could be any number of different assets. It could be sharing a business. It could be shares that you have maybe in your brokerage account. It could be real estate. It could be bank accounts, savings accounts. It could be physical assets. How does this all kind of how does this all come together when it comes to inheritance?
So again, another question I get asked is, do I really need a will in the UAE? I'm here, on an employment contract. I haven't bought real estate. I don't own my car. I just have a bank account where my salary gets paid. Do I actually need a will? So my answer to that is, well, it depends. First of all, you've got a bank account, and that is an asset which needs to be administered in the event of death under UAE inheritance laws. So the general rule is that any asset which is registered with a government department has to be formally administered. And when we say formally administered, it means that there has to be an inheritance order issued by the relevant court. And that inheritance order will be based on either a will, if one has been put in place, or the default inheritance rules. So if we work backwards, that one bank account that you've got, if you've been accruing your salary in that, it could be a sizable balance. Similarly, if you've been working for your employer for a number of years, you're accruing an end of service gratuity. That gratuity is also another asset of your estate if you pass away whilst you're still in employment. So in the event of your death, that gratuity will be paid out to your estate, as will the proceeds of that bank account. And those will only be paid out once an inheritance certificate or an inheritance order has been issued by the local court. And as I said, how is that determined? Well, it's either a will or it's the default inheritance laws. Now, of course, there are other expats and other individuals who will, have a lot of assets. They will have invested in real estate, for example, maybe commercial property, they may be off-plan properties. So again, all of those assets are registered with a government department through the land department. And in the event of death, they will need to be administered in order to be transferred to the heirs or the beneficiaries.
So my Beanie Babies collection from 2005, that's something I need to take into consideration, eh?
If it's important to you, yes.
Fair. But I've seen an interesting one, life insurance. And we often forget about this, but like our employment life insurance, right?
Yeah, absolutely. A lot of people forget about it. So it's quite I think standard for a lot of employers to offer life insurance as part of a remuneration package. And maybe when you start your new job, you get a lot of forms from HR to fill in, a lot of documents, and you need to share a lot of information. Amongst those forms, amongst that information would probably be a life insurance nomination form. And most of us will fill it in, or we won't fill it in, and we'll forget all about it. But it's so important to make sure it's filled in, because if you don't fill that life insurance form, that life insurance nomination form in, then any life insurance that has been taken out by your employer on your behalf will also form part of your estate. So that means, again, you need a will, or that it will be default inheritance laws. But if you had filled in that form, then the employer can pay out the insurance proceeds very quickly and very easily to your surviving family, without the need for any court processes. And I've seen how it can be a really important injection of cash for a family at a time when they need it the most. So when perhaps, they've obviously been hit by trauma of somebody passing away, they perhaps don't have immediate access to funds to pay for example, flights or school fees or rent, etc. That life insurance policy, if the beneficiary form or the nomination form has been properly completed, can help the family with with a cash lump sum, and it's incredibly useful for them.
Very, very good one. Good to tip there. I mean, I think many of us probably have forgotten what we had signed whenever we started with our employers, and it could be the case that we've left it blank, and that has dire consequences as a result. It could delay the money and the proceeds that the family may need. So it's a very easy one. So for all of those who picked up on that, might be worthwhile just reaching out to your HR first thing tomorrow morning, saying, "Hey, look, by the way, my beneficiary form, did I update it? Is it blank?" Just maybe have a quick review.
Yeah.
What about our biggest assets for most of us? Never mind the physical assets, but the ones that we brought into this world are kids, right?
Yes.
What happens in this case, right?
Yeah, incredibly important, as I mentioned before, and of course, a lot of families now are seeing the value and the benefit of bringing their children over, with them when they come to the UAE. They've got a new job, they want to set up a company, they're entrepreneurs, etc. I think gone are the days when typically the expats will come out alone and leave the family behind in the home country. The UAE has done an incredible job of sort of, making it so family friendly, the schools, the quality of education and healthcare, etc. A lot of families are coming here with minor children. So an incredibly important consideration is guardianship. If you pass away and you have minor children, and say both parents passed away, guardians are the people who will step into your shoes as parents and effectively bring up your children. So that's a huge responsibility if you think about it. It's not just who's going to look after the children, who's going to make sure they get ready for school, etc., and get dressed and brush their teeth. It's going to be looking after any finances, any assets that they inherit. It's going to be making those important decisions. Where do they go to school? Which country do they live in? So the only way you can legally appoint those individuals as guardians is in a registered will. In the UAE, there are will registration options, which I'll talk about in a moment. But I think in the UAE, we have an additional consideration. So usually you would appoint in a will, perhaps in your home country, you would appoint just guardians. And they would, as I said, step into your shoes as parents, if both parents were to pass away, and bring up the children, look after them, and give authority on behalf of the children for all those important decisions like medical care and education, etc. In the UAE, most of us don't have close family living with us. So when I say close family, I mean, perhaps parents, siblings, those individuals who we would perhaps want to take on the role of guardian. So what we advise is that you also appoint temporary or interim guardians in a will. And the role of the temporary guardians is to step in for that short-term period. If mum and dad both, for example, passed away in a car accident, children were at school, the guardians that are going to be permanent guardians perhaps live in the US or Canada or France or whatever, there's going to be a lapse in time before they can travel over or before the children can actually fly out of the country. So the role of the temporary guardian is to take care of the children during that interim period. we can now in both Abu Dhabi wills and DIFC wills name both temporary guardians and permanent guardians. And then you've got the whole sort of worst case scenario dealt with within a legal document. And if the need ever occurred, you've chosen the individuals who you want to care for your children in those circumstances.
So essentially the theme to all this is just the better planning makes for better execution, really, at the end of the day, right? And I'm reminded of a few years back when I used to work at HSBC, and unfortunately a colleague of ours passed away, really, quite sudden. And I remember the journey being very difficult for the surviving members, spouse, two young children, and if I remember correctly, it took upwards of a year just for that process to go through, because none of this was in place, really, at the end of the day. And it was a lot of court visits. And while I wasn't involved in the court visits and the discussions on a legal basis, we collectively were supporting the surviving, spouse with whether it be monetary means, groceries, or whatnot, which was a very difficult year because none of this was put in place at that point, or at least a discussion wasn't held, in this case. Wife didn't know anything about his assets. Everything was, under his name. And it just made it much more challenging in this case. So I guess the key takeaway that I'm seeing from this is that better planning makes for better execution, really, at the end of the day. So this particular slide, I think we want to spend quite a bit of time on this one, because this talks about the recent amendments. Is that fair to say? The recent changes that up until, these changes, the status quo was that, you need a will, or if you don't have a will, then it's going to go down this route. Now it looks like there's a few more options from what it sounds like.
Yeah, absolutely. So if we sort of, you see, as you said, the slide has lots of bits of legislation, and I'm not going to sort of go through that in much detail, but I think it's more important to tell you what the actual developments are and the impact they have on the choices and the options available now for both Muslim and non-Muslim expats who live in the UAE, who have assets in the UAE, and who have minor children. So one of the biggest and most exciting developments has actually occurred in Abu Dhabi. And what Abu Dhabi has done is set up a civil family court. And within the civil family court, it is now possible for all individuals, all sort of nationalities, to have a marriage registered, to have a divorce registered, and also to register a will. And because of the civil nature of the court, there is no restriction on religion. So as long as you are not a UAE national, any individual can actually opt into the Abu Dhabi civil court family process, and register a will. And that will does not necessarily have to follow any specific inheritance framework. You can include guardianship provisions in that will. You can include the appointment of executors, and basically divide the estate in any way you wish. So that's a huge development. It's allowing all expats a choice, as long as they opt into it, as long as they obviously follow the rules of execution of the wills. They can choose how their estate is divided. They can choose who they want to appoint as guardians for their minor children. Another thing that the Abu Dhabi Civil Family Court does is set out a sort of a default inheritance distribution, which is similar but not the same as Sharia. So to give you an example, and obviously this will be dependent on who survives a deceased person. If that individual passes away in the UAE and they don't have a will, the family can apply to the Abu Dhabi Civil Family Court for the default distribution, and that will allow 50% of the estate to go to the spouse, 50% to go to the children, and if there are female children and male children, so girls and boys, they will inherit the shares equally. So there is no distinction anymore in between the genders of children. So it really has developed quite quickly, and it's quite significant, especially in light of the laws that were, the situation that existed prior to this new law coming in place. We're seeing a lot of clients, coming to us wanting to opt into the Abu Dhabi Civil Family Court to register wills. We're also seeing, an increase in inquiries in relation to sort of marriages and divorces all through the Civil Family Court.
Mm. And just to clarify, so this is applicable for Muslims and non-Muslims expats.
Yeah, exactly. So because it's a civil court, it's basically non-religious. So it allows these traditionally personal status matters to be dealt with within a civil law framework. The other major development is the introduction of the UAE Federal Law number 41 on civil personal status. Now, this is actually a federal law. So federal law means that it's applicable to all Emirates. And this also has a similar default inheritance distribution to what exists under the Abu Dhabi law, but it only applies to non-Muslims. So instead of having a non-Muslim individual passing away and Sharia distribution being the default for them, this new law, Federal Law number 41, gives an alternative default distribution, which again is if there is a surviving spouse, he or she will get half of the estate. If there are children, they will get the other half. And again, there's no distinction between girls and boys getting an unequal share. So again, huge development, and I think it's steps in the right direction just to give all individuals the choice to be able to register a will if they want to, but also recognizing sort of internationally that individuals who want to move to the UAE and set up families and have homes here and work here and stay here for any length of time want to have laws that govern them, which are similar to what they're perhaps used to in their home countries. So I think it's incredibly forward-thinking and a lot of exciting developments.
A big step. It's a big change. And just to ask on this, Tasleem, so do you need to be an Abu Dhabi resident to put a will in place through the civil court in Abu Dhabi, or two, God forbid, you have a will in place, but your family wants to go to Abu Dhabi courts? Are you required to be an Abu Dhabi resident?
Not for the will, no. So this is why we've got a lot of clients who are happy to register the wills through the Abu Dhabi Civil Family Court, and it's not a requirement that you should actually be resident there or have a visa from there.
Okay, well, thank you for that. That's good insight. Any more on this page, or maybe we'll go to the next one?
I think, the sort of laws at the top, they're not so new, but I guess what they're just there to do is to illustrate that the wills processes that we have in place. So Abu Dhabi, of course, we've talked about, but the DIFC wills, which came into effect I think it was around 2015, they are also enshrined in legislation. So initially, when the DIFC wills service centre was introduced, there was a lot of sort of comments about, well, is the DIFC will actually legal? Is it going to be recognised by the court, etc.? Well, it is. There is a law there that quite clearly says that if the will is registered through the DIFC, then it is a legal will and it should be upheld. So I think, as I said, all of those laws together show some exciting developments in this area.
Sure, no, thank you for that, Tasleem. Okay, so I think this touches on, as I said, conversations I've had in the past where individuals said, I set up my will 10 years ago. My will is from overseas. I set up a Sharia compliant will. What do you need to ensure that your will is actually legally recognized in the UAE?
Yeah. Well, it will depend. There is no one line or one paragraph answer. It will really depend on what sort of a will you've already got in place, or what sort of a will you're planning on putting in place, what your nationality is, what your religion is, what assets you have that you want to include in the will. And when an analysis has been done of all those factors, then only can you really answer the question, what do you need to do to make your will legal? So I'll give you an example. If you're planning on registering your will through the DIFC court, the first consideration is that you cannot be a Muslim, because the DIFC Wills Service Centre is only for non-Muslims. The second point to note is that the will does not actually have to be translated to Arabic because it's being registered through the DIFC. So that's for a DIFC will. If you're registering a will through the Abu Dhabi Civil Family Court, it doesn't matter what your nationality is, as long as you are not a UAE national. But your will does actually have to be translated to Arabic. So, you know, it's not something that's just a hard and fast rule for everyone. It's really, you do have to sort of check what applies to your circumstances.
Okay, thank you for that. We've got a number of questions coming in. So maybe what we'll do is we'll cover the next few slides really quickly and jump into the questions. I think there's a great learning opportunity in the questions. So maybe we'll talk about the Abu Dhabi Judicial Department first and talk about the
Yes, just a bit more information, because as I said, this is a new development. We've talked about the laws that sort of have introduced the development. I've said that the will has to be translated to Arabic. The jurisdiction of the will, so usually we advise that you restrict assets based in the UAE to be referred to in an Abu Dhabi will. Non-UAE national Muslims can register, which I think is quite an exciting feature for it. You can include guardianship provisions, both temporary and permanent. It is a new process, so there hasn't been much in the way of probate cases, so we don't have that much of a sort of an insight into different outcomes when somebody has passed away in terms of sort of process, probate, etc. But again, you know, with time that will come, that will happen. Yeah, I guess most importantly, you don't need to physically go to Abu Dhabi if you want to register will. You don't have to go to the Abu Dhabi court. It's all done virtually, and you can register will virtually from any part of the world.
Amazing.
Similarly, with the DIFC, again, there's no need for you to physically go to the DIFC to register your will. It's all done virtually. As I said before, there's no need for translation to Arabic. You can include guardianship and executors and beneficiaries. I guess with the DIFC, the significant feature is that it's been in place since 2015. So it's tried and tested in the sense that a lot of clients who have registered wills through DIFC have sadly subsequently passed away. I've dealt with DIFC probate matters, quite a few, and the process works. It's incredibly quick, it's efficient, it's fairly easy, and I think that the speed at which probate is issued in the DIFC is quicker than a lot of sort of other common law jurisdictions as well. So it's a very efficient process and a good option for those who own assets here and want to make sure that those assets pass in accordance with their wishes.
Thank you for that, Tasleem. Execution of UAE wills?
Yeah. So yeah, again, this is just to sort of again emphasize that there's no need for personal appearance at either of the courts. And you know, remote registrations. I think everyone's so used to conducting so many different transactions virtually now that it doesn't even feel unusual. You know, but what it does do is it allows clients who don't necessarily live in the UAE but perhaps own assets here to register a will from wherever they're living, and it's no longer an excuse that, oh, I have to go back to the UAE in order to sort out my affairs there. It's not. You can do it virtually from wherever you are.
Brilliant, brilliant. I think this one's self-explanatory. A will has no effect until you die. It's not like a power of attorney. It's completely opposite of that. But maybe if you want to add a few points on this one.
Yeah, so it sounds obvious, but it's important to remember that a will is a flexible document. So you make a will now, but your circumstances, if they change within a year or 2 years or whatever, you can change the will, and you can keep on changing the will to adapt to your circumstances literally until the day you die. But there are some things that may happen in your life that affect your will without you realizing. So a really good example is if you make a will when you're single. If you get married, in most jurisdictions or in a lot of jurisdictions, your will that you made when you were single is automatically cancelled on the date of your marriage. So if you don't realize that or you don't know that, then you thought you had a will, and just because now you're married, you no longer have a will. So the message from this slide is that any major life event, marriage, divorce, having a child, changing finances, moving jurisdiction, they should all trigger that sort of thought to review your will. Is it still valid in the jurisdiction? Is it still saying what I want it to say? Does it still apply to my circumstances? Yeah.
Got it. Well, thank you for that. And the need to update it on a regular basis. That makes absolute sense. Even when it comes to assets, new assets that you might acquire, maybe not necessarily if your balances have changed, but more if you have new assets that you've acquired that you may want to jot down a note on your will. I think it's time for the Q&A. And I'll ask, I don't know if you have a meeting right after. It's about 6:50 right now. And typically we close this at 7. Would you be able to stay an extra 10 minutes to Tasleem if you have the time?
I do, yes.
Thank you very much. So we'll jump into the questions. We've got a number of them, and I'll just take it in succession. What I'll do is I'm going to leave the Sarwa-related questions for me to answer, but I'll answer it offline. I'll send an email to all the individuals who've sent the questions because I want to make sure we give time to for all the inheritance-related questions. Let's talk about, it says here by Nayara, what is the process for wills for Muslims in the UAE? I think we touched on it, but essentially I think they're asking about, well, how do I go about getting a will in place from?
Yeah, so as I said, as long as you're not a UAE national, you have the option of registering a will through the Abu Dhabi Civil Family Court. And it's the process is sort of the same as it would be in any other country. You'd decide who you want to appoint as your executors, as your beneficiaries, as your guardians. You can consult a lawyer to prepare the draft for you. And then there is a registration process. So the registration process first involves getting the will translated to Arabic, then submitting it to the court for approval. Once the court has approved it, you pay the court fees, and then you have the ability to basically choose an appointment date and time, and then you appear on that date and time. Prior to that, you're sent a link for the video call. And once you join that link, the court official will go through the will with you. Once everything's in order, it will be registered, and that's it. Your will is complete. You will be issued with proof of the will and a copy of it, and then hopefully you'll live a long life. But in the event of the worst happening, that will can then be submitted by your executors to the court to obtain a probate order to deal with the assets that you own.
Brilliant. Thank you, Tasleem. Faisal asked a question, and I expected this question to come out. How do international wills, for example, Canadian in this example, says take effect in the UAE? Would it be upheld for local assets?
It's a tricky question because, again, it depends on how the foreign will has been drafted, the jurisdictional scope of the foreign will, and what assets you actually own here. So generally, if you own real estate in the UAE, but you have a foreign will, it's not going to be effective to deal with the real estate here. You must have a separate local will registered, either through DIFC or Abu Dhabi. But if you have a foreign will and you only own movable assets here, it is possible to have that will upheld, but it's a very long and costly process to do so through the local courts. Sometimes the courts will require the will to have been probated in the home country first, and then translated, notarized, tested, etc. They will also require the legislation that governs the foreign will to be translated, notarized, tested. All of that has to be submitted to the court, and you can imagine it takes a long time for that process to go through. In the meantime, local assets are frozen and cannot be transferred. So our advice is it's always easier to put a will in place locally if you have assets here, and to segregate wills. It's nothing unusual anymore to have more than one will. I think traditionally it was expected that you would just make one will, your last will, and that would apply all across the board. But now clients have assets in various different jurisdictions. They have different types of assets, and different laws in different jurisdictions will sometimes conflict. So the best advice is that you look at each jurisdiction separately and see what needs to be done for those particular assets. If that means multiple wills, then that's fine. But you have to be careful that they're drafted appropriately and they don't inadvertently cancel each other out.
Got you. Thank you very much for that, Tasleem. There's a question here. Well, I think it's more related to the Sarwa beneficiary nomination. If I signed a beneficiary for my Sarwa account and I am subject to Sharia law, what will be the validity of this beneficiary that I sign? And it's a brilliant question, and it's something that's actually written right into the terms and conditions on there, where with Sarwa Invest and Sarwa Save, you're entering into a contractual agreement where you are telling us, you are communicating to us what your wishes are. God forbid something should happen to you. And our role in this discussion is that we are going to execute accordingly. Now, if we are not aware that you've passed away and we get a court order indicating to us that, you know, this person has passed away and this is exactly how the assets are meant to be bequeathed, we are going to follow the court order. However, if your family members inform us, or, you know, next of kin or whatnot, and we go through the verification process that you've passed away, as in we receive the death certificate and the notices and whatnot, we will execute accordingly to what your nomination is. So until, you know, further notice, until we've received any notification from the courts, we will follow the what you have appointed on your beneficiary notice. And this is why we've opened it up to anyone to dictate as to how they want their assets to be bequeathed. So yeah, just to answer that question. Let's see here. Do you recommend a non-Sharia compliant will, which is apparently allowed in the UAE? I think we've covered that already earlier on. So if you don't have a will, the question is, what does Sharia law say? And I guess it all depends on the situation, right? But maybe we can touch on that one more time. So if you don't have a will.
Okay, so if you don't have a will and you're a Muslim individual, then Sharia law will determine who inherits and in what shares. So if you remember the slide that we went through, a couple of slides we went through earlier, if it's husband and wife and they've got 2 children and parents are alive, that's the Sharia distribution for that particular family. Obviously, the distribution will differ depending on who survives you. So if you have 2 boys and 2 girls, then the distribution will differ. If your parents have both predeceased you, the distribution will differ. So it is within the personal status law how the actual division is decided, and an application has to be made to the personal status court in order for the judge to determine who inherits what in accordance with the Sharia rules.
Thank you for that. Can you share best practices to cover assets beyond UAE? Are there any platforms, options to digitize the process to make it easy to update? I think essentially they're talking about wills. I think you touched on it, where it's probably best to have a will in different jurisdictions to covering those different assets. I think this individual thing is a very easier way of doing this, really, at the end of the day, because it could be quite onerous, really.
I guess, but I think if it comes back to that sort of point that you made at the beginning, Eamon, about, first of all, perhaps putting in place some kind of a schedule of your assets. You know, you don't have to put down values, etc., but at least what you own. Start with the biggest, you know, real estate, properties, etc. Move down the list. What are they? Where are they located? What's your interest in them? Is it jointly owned? Is it owned in your sole name? Who is it administered by? And once you've got that in place, that schedule as a starting point, it becomes a lot easier to sort of at a glance see, well, actually, you know, I own a property in France, maybe I should put a will in place in France. You know, I own property in the UAE, maybe I need a UAE will. I own investments in Switzerland, maybe I need to look at a will for Switzerland. So once that once you start doing that exercise, I think it becomes a lot easier. But also, I think it's incredibly important to get legal advice to make sure the interaction between multiple wills and your own circumstances is right for you, because there's not only, of course, inheritance, there's tax as well, there's domicile, different taxes apply to different individuals, to different assets, and to different jurisdictions. So it is a big task, but I think, you know, you've got to start at some point if you've got that kind of wealth.
Thank you for that. There's a question here relating to, I mean, it's a mix of estate planning and also tax planning a bit. So, you know, let me know if maybe this isn't the appropriate question to ask, but I'll ask anyhow. It says, I'm investing in, you know, these 2 particular ETFs through Sarwa Trade. Am I protected from estate taxes, even if both ETFs are US assets? If so, does that mean my kids will have 100% without any deduction? And maybe I'll touch on that first, and maybe I'll open it up to you. So on Sarwa Trade, as we know, there is no beneficiary nomination option. It's just not a legal capability at this point in time. What we do know is that the moment that your assets surpass the $60,000 threshold, you are exposed to U.S. estate taxes because these assets that you're purchasing through Sarwa trade are U.S. Domiciled assets themselves. And that's any asset above the $60,000 threshold is subject to U.S. estate taxes, which could be as high as 40%. God forbid, knock on wood, something should happen to you. I guess my question maybe in this case and relating to this one, Tasleem, is that what happens in that case, right? I mean, you have a client who has assets in a brokerage account, whether it be the interactive brokers or the whatever it might be, they have assets there, they pass away. What typically happens in that scenario if they have significant assets well above the $60,000 threshold?
Well, first question would be, do they have a will in place that covers those assets? Because if they can't fill in a nomination form for it, then they should be dealing with it or determining how that asset should pass in the event of their death. What sort of a will do they need will depend on, as we said, their individual circumstances. And then if it does look like that asset is going to trigger some kind of an estate tax or an inheritance tax, they need to take inheritance tax advice from an appropriate advisor who can advise on whether it's US taxes or the tax exposure for that particular individual.
Okay. I figured it would be complex, but it makes absolute sense in here. There's quite a bit of disbelief about the fact that Muslims can now appoint or create a will. I think quite a bit of surprise on here. So Mohsen Saeed, yes, from what we've learned today, it's a relatively new update that there is a provision or an opportunity that being an expat Muslim, you can appoint or create a will. Sorry. How does UAE handle liabilities or loans of a person who's passed away? A brilliant question, actually.
Yep, they have to be paid from the estate. So, it comes back to if there is a will in place, the will will probably refer to all debts and liabilities being settled before the assets can be distributed to the beneficiaries. It depends on what sort of a liability you have. If you have, for example, a personal loan with a bank in the UAE, a lot of the times there is the offer of sort of an insurance policy to cover that loan that would kick in the event of death. So check if you've inadvertently signed up for that, because obviously that's incredibly valuable. If you are taking out a major loan and in the event of your untimely passing, if that loan is paid off with an insurance policy, that leaves the situation a lot more comfortable for your family. If there is no such insurance, etc., then it's up to the bank to take steps to seek to recover the outstanding dues, and they may do that via the court, via the assets that are owned. So it all depends on, do you have an estate which is in credit and can pay off the debt or not.
I'm familiar with typically if you take a mortgage to buy a property, there is a requirement that you have to obtain a life insurance policy, and sometimes
it's mandatory.
It's mandatory, right? And it's something that's kind of either built into the mortgage at times, or sometimes it's an independent life insurance policy. So in that case, the liability is paid off and the asset is basically unencumbered at that point in time. Does that happen for credit cards or personal loans or any other ones? Like, I've never come across that, but I'm just curious to see if you've ever come across that before.
Yeah, so I have actually seen it. Some credit cards will offer like a payment protection insurance. A lot of the times it's not mandatory for you to apply for it. Sometimes as part of introductory offers, etc., they will throw it in as a freebie. And you may get it free for the first year, etc., and then you can start paying for it as part of your repayments. And as I said, it's incredibly useful if it's there, but sometimes banks being banks, insurance companies being insurance companies, it's quite a high monthly repayment, so a lot of people don't take it up. But as I said, if it's there, then it clears the liability immediately upon death, and the family are free to then deal with any assets that are there without having to worry about the repayment of liabilities.
Brilliant question here. And the guys, don't be shy about putting your name. So Anonymous has had a lot of brilliant questions today. Are there any tax or cost implications to inheriting assets?
In the UAE?
Yes.
No, so there's no inheritance or estate taxes in the UAE. At the time assets are transferred, so particularly with real estate, for example, if you leave real estate in a will, or if you don't have a will and real estate is to pass to your heirs, at the time that title to the real estate is transferred, there will be some small fees to pay to the land department. They're not, they're not significant. They're just more administrative fees. But really, those are the only sort of fees or taxes, as it were, that need to be paid in the event of death. Otherwise, heirs and beneficiaries would just inherit the estate value intact.
Thank you. Brilliant. If my son or daughter are below the age of 18, I think it goes back to the question about sorry, the name. What's the title? Sorry. So essentially, what was that again? Say that again.
Sorry, did you say it's about guardianship?
Thank you. Thank you. The name was slipping me. So if a son or daughter are below the age 18, who controls their share until they're 18?
Yeah. So again, it comes back to, have you registered a will and named guardians in the will? If you have, then the guardians will control and manage the assets on behalf of the minor children. And just a point, it's in the UAE, the age of majority is actually 21. So while a child is under the age of 21, a legal guardian is required to manage assets on their behalf. In other jurisdictions, it is 18. In some, it's 16. But in the UAE, it's actually 21. If there is no will and there are minor children, then the court will basically appoint a person to be the legal guardian for the minor. It will typically follow the Sharia principles. So if, for example, dad has died, then it would be the next male relative of dad who would be appointed as the legal guardian.
Brilliant. Thank you. I heard there's an option where certain family members, father or mother, can do a tanazul, i.e. give up their shares to the wife if the husband dies. Is that true? I don't know if you've heard of this term before, tanazul, Tanazul. I apologize if I mispronounced it, by the way.
Sorry, what did they say? They give up the shares?
Yeah, it says, I heard there's an option where certain family members, fathers and mother, can do a tanazul, i.e. giving up their shares to the wife if the husband dies. Is that true?
Okay, so I think what's being referred to is a waiver. So if you have a Sharia situation and particular individuals benefit from the estate, so if we go back to that slide that we saw earlier, you have husband dies, wife inherits, mother and father of husband inherit, and the two children inherit. It's possible within the Sharia framework for, say, mother and father to give up their shares to the wife, to say, we don't want to receive our 1/6 share, we will give them up to you. So the wife will inherit not only her own 1/8, but she'll also receive the shares from the parents because they've voluntarily disclaimed them to her. So that's something that's possible within a Sharia inheritance process. We've done that many times where families, if Sharia has applied, but, families don't want it to be divided in that manner, they can do that. But it can only be done, number one, after the death of the individual, so it can't be done in advance. And number two, it can only be done by adult beneficiaries or adult heirs. So if the children are minors under 21, they cannot give up their shares because they're minors.
Thank you for that.
I hope that's what the person's referring to.
I'm going to safely assume yes.
Okay.
There's a question here, and I'm just consideration of time. And the thing is a very big one. What happens in the case of a joint account and someone passes away?
Yeah, good question, because I think it's a very, very important, relevant question. So in the UAE, all assets are frozen on death. And what does that actually mean? So in the context of bank accounts, if you have a sole bank account or a joint bank account, once the bank has been informed of the death, they will put a freeze on the account. And the purpose of that is, of course, to preserve the assets, preserve the balance. The bank wants to make sure that there's no unauthorized withdrawals, etc. And they want to preserve that balance until they have received court notification of who is entitled to that. So in the context of a joint bank account, you will typically have, say, husband and wife who've got a joint bank account. One of the spouses passes away, the bank finds out about the death and will put a freeze on the account. That means that the surviving spouse will no longer have access to that joint bank account. So that can obviously cause a lot of financial devastation if that's the only account that the surviving spouse had access to. So practical tip, make sure the joint account is not the only account that you have. Make sure you have an alternative fund or access to an alternative account for cash, in the immediate aftermath of something like this happening. It doesn't necessarily have to be a local bank account, it could be an offshore account, as long as you have the ability to quickly access cash, at a time when you perhaps need it most.
There's a number of questions, and there will not be enough time.
I can see
minutes in our presentation today. What I'm going to do is I'm going to take one more. And then what I'm going to do is if it's okay with you, I'm going to share your contact details with everyone here. And for those who've posted the questions that I am able to answer to from a Sarwa perspective, and you actually did write your name and your email address, I will be able to respond back to you. And apologize for those who wrote an anonymous that your details won't be recorded, so I won't be able to respond back to you, but I will share your details. There's one last question, and I think it's a complex one, but I think it's one that might be good to answer. In case of a mixed couple, where the wife is Emirati and the husband is non-Emirati, both are Muslim, what are the applicable inheritance laws in this case?
So the wife, are we talking in the context of wills or inheritance?
It doesn't say. I'm going to assume inheritance. Oh, sorry. What are the, I apologize. They said, what are the applicable inheritance laws?
Okay. So if both are Muslims and both have not, well, if both are Muslims and the non-Emirati husband has not registered a will through the Abu Dhabi court, then Sharia law will apply to their respective estates when they pass away. And Sharia law will, work as we've already seen on that slide. If they want to register a will, only the husband can, because he's not a UAE national. Wife cannot register a will through the Abu Dhabi court. She can, if she wants, register a will, a Sharia compliant will, which under which she can give up to a third of her estate to a non-Sharia heir. So those would basically be the options. There are other options depending on sort of what sort of assets they own. So there are now foundations available in the UAE, which are sort of a type of a structure similar to a trust. So the family can look into those if they want to structure their wealth on a larger scale to determine succession of assets that they own. And that's something that we're seeing a lot of interest in as well, because the UAE laws governing those are developing all the time. They're working incredibly well, and they're very useful vehicles which give a lot of benefits, one of them being succession planning.
Actually, you know what, that's a topic for another webinar we could potentially do together, Tasleem, about legal trusts and whatnot. So, it's a very interesting one that could be a solution for a number of individuals to help them, decide how they want their assets to be bequeathed. This is how you can get hold of Tasleem. Created a QR code where you'll be able to have her contact number and her email address. She is an associate at Stephenson Harwood, Middle East, LLP. Offices are in DIFC, if I remember correctly, right?
Yeah, Burj Daman.
Burj Daman, exactly. Yes. So I'll leave this on screen for a few more seconds, just so everybody can be able to put your phone and kind of scan the QR code. This whole presentation has been recorded and will be shared with you. So don't worry if you've missed anything or if you've attended the webinar late. I think we had a really great turnout today, lots of questions, and I apologize to everybody that we weren't able to answer it, but I do need to let Tasleem go and have dinner and see the kids, and I as well. Thank you to everyone who has joined us today. Thank you for the insightful conversations and the great questions, and definitely welcome you to reach out to us here at Sarwa, and of course reach out to Tasleem for more of the inheritance and legal aspect of things, but anything related to Sarwa and provisions of your account, more than happy to answer that for you here, and I'll answer all the questions that you have over the next coming days for those who pose questions that we were not able to get to. Any last words, Tasleem?
No, just thank you very much. Thank you to everyone who joined. You've got my contact details. I'm happy to receive questions, and thank you again, Eamon. It was fun.
Thank you again for joining us once more. Really appreciate it. And good night to everyone. Thank you very much.
Thank you. Bye-bye. Hello.